Well, welcome back to TuckerAllen Live. I'm Scott Trout, and as always on Fridays, when we bring you TuckerAllen Live, I'm your moderator, and I'm joined by the TuckerAllen attorney, Missy. Welcome.
Hi, Scott. Thanks for having me.
Oh, as always, Fridays, fun to get together at 1 o'clock and just spend 10, 15 minutes talking about topics on estate planning, and today is no different. Always keep in mind that a consultation is actually the best thing to do and schedule one by going online at TuckerAllen.com. We don't want to give you legal advice here. We're just really educational, informational, some tools just to equip you to have some talking points with an attorney who practices exclusively in estate planning. So let's get started. Topic for today is what happens if a beneficiary dies before you do. Unusual situation, something that I didn't think about, and it's really intriguing to me. So I'm going to give you the scenario, and then we're going to walk you through and see what it does into that situation. So we have a single person with a daughter and a son. Daughter has 2 kids and son has none. So what happens if one of the beneficiary, and if no one has a will or a trust and someone were to die?
All right. Well, the good news is the state of Missouri, or whatever state you live in, has a plan. So that money isn't going to poof away. But the catch here is that you're not going to like the state's plan. So your estate is considered intestate, meaning there's no will or trust. So it goes to the law of the state that you passed away in, and they have a list of who's going to get your money. It often doesn't go where you think it might will. So in the situation you provided with the 2 kids, one of which has grandchildren and one of which has no children, if the parent dies, the money's split 50-50 between the 2 kids. But if one of those beneficiaries dies, then if the son dies and he has no kids, that means the daughter gets 100%. And if the daughter dies, but the son lives, that means the 2 grandkids are going to split the mom's 50%, and then the other 50% goes to the surviving son. That seems like a pretty straightforward answer, and that makes a lot of sense. But what if you have a significant other you've been living with for 30 years, or something along those lines, and you wanted the house to go to your significant other because you've lived there forever together, and you don't want it to go to your adult children? They have their own houses. So according to the laws of the state of Missouri and every other state, if you aren't married, then that person doesn't get any of your inheritance. It completely bypasses that person. So that's one example of how this is a problematic setup, and you might want to get a will or a trust, have it go where you want it to go.
Something we've been talking about for 13 or 14 months is to not have one or the other, at least take a step and do the will. I mean, I think it's this scenario is one which I don't think I've ever contemplated. It's hard for maybe many people that are watching or that ultimately listen on the replay that they'd ever contemplate a beneficiary dying before you. It's kind of your worst case scenario of having one of your children die before you. So let's go with, well, maybe first of all, beneficiary. What does that mean? Maybe I want to make sure we always try to break down some legal terms. What is a beneficiary first?
So a beneficiary is someone who's going to be getting your assets when you pass away. It's a pretty generic term. It could mean your heirs under a will. It could mean under a trust, or if we're proceeding intestate without a will or a trust, we could still use the word beneficiary to describe them because they might not necessarily be your children.
Right. And so it may be duplicative, as I was listening to you talking about if you don't have a will or a trust, but in the scenario in which, let's say you've created a will or a trust, and one of your beneficiaries, one of your heirs, one of the people that are supposed to inherit your money, what if they die? And what happens in that scenario when you have a will or a trust?
All right. Well, if you have a will, then ideally your will says what should happen when that person passes away. There should be a backup scenario in there, just in case, because these things are pretty foreseeable. So usually when you set up your will, your attorney is going to ask you, hey, what happens if this person passes away? So you've already got a plan in place. The downside of it with a will is that a will by itself does not avoid probate. So think of a will as an instruction sheet to the probate court. So if you said your assets are going to go to your son and daughter equally, and your son passes away, your will should say that everything's going to go to your daughter 100%. However, we still have to proceed through probate which is several months, at minimum of 6 months before we're giving money out and closing the estate, if not closer to a year. And it costs thousands of dollars to go through probate. So at least you've got a plan in place and you're deciding where you want your money to go, but it's not a fast or cheap method to go through probate.
So that's only if you have the will, right? Is that what you're
Correct.
saying? And so the trust, I always think of that the terms everyone used, and it kind of helps direct what happens in scenarios like this, right? So it may be, you won't have to worry about the statute if the trust is drafted appropriately and a beneficiary dies, it goes accordingly and you'll provide for that?
Yep. So a trust is the third option here. So with a trust, it has the same setup of where you want your stuff to go. It'll be rerouted appropriately, and you still have the benefit of avoiding probate. That's the big difference between a will and a trust, is that when you have a trust and it's set up properly, your asset skips over probate and that 6 month minimum waiting period to get money and the thousands of dollars you spend going through court, and it goes directly to your beneficiaries, and it's much faster and much cheaper to do it that way.
So yeah, an example, I had a friend whose family member passed away, and he was one of a number of kids, and all of them predeceased him. And so that would be the scenario by which, if they were equal beneficiaries, but they all predeceased and had no one else living, and it kind of their lineage ended, and it's just this one person, they get it all, I guess, according to the trust, if that's what the trust said?
Yep.
So a car, accounts, whatever, if they were properly funded or titled right into the trust?
Correct.
So speaking of titling and funded, what if you had a TOD? What happens in the situation where you have a transfer on death? What happens in those circumstances?
So a transfer on death, also called beneficiary designation or beneficiary deed if we're talking about a house, just says that upon your death, that asset is going to immediately pass to that person and skip over probate, which is a huge bonus for people that are going to have a will. But the downside to this is oftentimes you can only name one person or one level of people with a transfer on death. So for example, a car, you can only put one name as transfer on death on a car. So if you have multiple kids, that could be a problem. Got another problem with that one is if you can name multiple people, if one of them dies, the other one's going to take everything, and they might have kids of their own. So if we go back to that scenario before where there's the mom with the 2 kids, if we put down daughter and son on a bank account and daughter died, that means son's taking 100% and those grandkids get nothing.
So in the situation, maybe it's getting complicated as I think through it, and you have a will and a trust, but you took a car, used a TOD, and that person who was TOD died. Does it go back in like that kind of catch-all provision into the trust?
If you have a pour over will, it does. But if you don't have a will or a trust to take care of it, it's going back into probate, and then you've got to go through probate with a car, which is a lot of money for an asset that might not be very valuable.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
So I know it begs the question, someone's watching that does not have a will, does not have a trust. They're thinking, oh gosh, I now have someone I maybe put on TOD who's died. What steps should they be taking other than the obvious, which is make an appointment, get a will and a trust? Should they be retitling? What is really the right course of action to start, right? I mean, each circumstance is unique, so we really, you can't really tell everyone in a general swath what to do, but what would be the right start?
The first thing that they should do immediately is to contact wherever that asset is held. That means going to the DMV or going to the bank and telling them that you want to change your beneficiary and put at least someone's name on there. Then hopefully you talk to your attorney and your attorney can set up a will or a trust for you, but at least get yourself covered, because we don't work it instantly. It takes us a little bit of time to meet with you and talk out a plan.
So someone likewise watching, I like throwing these questions to you that you're not prepared for, right? So, and they have a will and a trust, and they're thinking, okay, one of the beneficiaries in my will and trust has died, or multiple. Should that be a situation where we've talked a lot in weeks prior about the legacy protection program, about making changes to your will, minor changes, beneficiary designations? Is that where that instance would help if you had the legacy protection program?
Absolutely. So if you're a member of our legacy protection program and one of your beneficiary dies, you just come on in and you tell us what's going on and where you want their share to go, and we'll get your documents updated for you at no additional charge.
So even if they don't have the legacy protection, they should at least go to make some changes. Go to your attorney, make some changes to your will, your trust, just to be safe. I mean, otherwise, even if you didn't, the trust, if drafted appropriately, would control and operate in the manner which would just flow down to the other beneficiaries. But it's cleaner just to get it changed, right?
Correct, certainly. Also, you want to have a backup for that person in place for the backup. Does that make sense? So if you put down son, we want to make certain, and son died, we want to make certain that the backup is in there, and we want a new backup for that previous backup.
And there's always the law school question about simultaneous death, which is kind of a crazy situation. And I want to think back to one of our virtual town halls. I think we talked about how institutions may determine like when to actually the timing. Is that right? If in situations like this, if both of them are beneficiaries or something to that effect?
So it really depends upon the institution, like you mentioned. So in our wills and trusts, we typically have language saying that if this person lasts 30 days after my death, then it would go to that person. But if they don't make it to 30 days, then we reroute to this other person. So that way it doesn't go through the deceased person's probate estate. So then you'd have double probate possibly, which is something that would be terrible. But most of our stuff, we like to have that language in there to avoid it.
Yeah. And I think, as we've been doing this for a year now, and you think about how we urge people to take action, get a will, get a trust, get a power of attorney, a healthcare directive. Again, and I said this last week, and that is we do it, and then you have this sense of, okay, accomplishment, finality, I'm done. And it really isn't. You need to kind of make sure that it does keep up to date. For example, in 2020, the CARES Act came out, and maybe there were some changes you need to make, or beneficiaries change, or you add children, or you acquire property, and that comes right back. And maybe this is where we'll end for the day, is again, maybe just talk again about the legacy protection program that TuckerAllen offers, and why. I had someone ask, hey, can I be part of that even though I wasn't a client? Of course, the answer is yes, but maybe talk one more moment about the legacy protection program, because it seems so applicable in a situation like this. If you need to make changes, don't go and spend all that extra money on a one-off with your attorney rather than annually where it's included. So go ahead and talk about that.
Sure. So the legacy protection program has a lot of different benefits, but this is a big one, is that if something happens, or not even if something happens, you just change your mind, we can make minor changes to your documents for no additional charge beyond your enrollment fee in the program. So if you decide that you no longer want your son to be your healthcare power of attorney, to make healthcare decisions for you, you just call us up on the phone and let us know, and we'll get the document changed so that he's no longer your first person there. If someone else dies that's on your list, then you let us know and we get it all rerouted so there's a new backup to your backup.
Mm-hmm.
Some other things.
I liken it to an oil change, right? You should get an oil change every 9,000, 12,000, depends, new cars now can go 12,000 miles. And okay, let's just do an oil change on your trust and your estate planning every 12 months, annually. Let's just get you in here. Let's do a tune-up, a checkup, and let's see what needs to be changed, if anything. Let's see what the law, look, we just talked last month about the Biden administration and the potential for the change in the death tax, and who knows, and the capital gains, and the stepped up basis, and who knows where it'll go and what changes may need to be made. And some of those may, or certainly the minor things will be covered under the legacy protection program. And I think it's an amazing, unique idea, because it does, for me, I can be, rest assured that, annually someone will say, hey, it's time for an annual review. Let's just check it. It's complimentary because it's included in the program. We can do it via Zoom. We can, just check in and let's see what's changed. If anything, if nothing, great, we'll see you next year. And that's why, to me, it's a really nice add-on to an estate planning that many people don't think about, because you do. I did my plan. I'm like, oh, done. I don't have to worry about it. Let it collect dust. And now, of course, when I do these every week, I worry. And now I've got to make some changes. So anyway, Missy, thanks as always for joining and talking about something that's unique. And that's when beneficiaries may predecease you and what happens and what steps you need to take. So thanks for joining. I appreciate your time today.
Thanks, Scott. It's always a pleasure.
Well, as always, 1 o'clock Central Time. You can join us right here on Facebook at TuckerAllen Live. Look out for the next month. We're going to do another virtual town hall where we'll have the attorneys from TuckerAllen join. You can log in, ask questions live, and get answers about the issues that matter most to you. But obviously, the things that's most important is scheduling consultations, getting things done. Don't delay. If you don't do it now, when are you going to do it? And especially when we're coming off the heels of a pandemic, it's just time to make those plans. So the attorneys are ready to hear from you. You can do it via Zoom, WebEx, telephone, in person. You have offices in the St. Louis metropolitan area and up in Kansas City as well. So check them out at TuckerAllen.com. Follow them on social, and then see you next Friday, same place, same time. We'll cover another topic with the attorneys from TuckerAllen. Have a great weekend.